Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers obscenity, free speech, and the duty to protect, and is brought to us by Mr. Porter's channel. Be sure to check out the description below and give them the credit that they deserve. In August of 2020, 41-year-old Sean Porter was protesting Maryland Governor Larry Hogan in the crosswalk of a busy intersection in the city of Bowie. Mr. Porter was holding a large, handmade sign with various insulting profanities directed at the governor, and waving at traffic as they honked and drove by. After standing in the intersection for a few minutes, Mr. Porter was initially contacted by members of the Prince George's County Police, who gave him no issues. Several minutes later, Officer McKenzie and Officer Arnold of the Bowie Police Department arrived on the scene.
How you doing, sir? Hey. I don't want to give you a hard time or anything, but I can't let you hold up that sign.
I'm sorry, the First Amendment protects my free political speech. You're live on YouTube, video and audio recorded.
That's fine, sir. Your sign's a little vulgar and it's upsetting people.
It doesn't matter. You're not the free speech police.
I understand that, sir.
I have a constitutionally protected right to say whatever I want. I'm politically protesting Governor Larry Hogan. It's my First Amendment right on the right to petition, my right to redress of grievances, and my right to file a complaint in any manner I feel fit. By the way, I'm not trespassing. I'm on public property. I'm on a public crosswalk. I'm doing nothing wrong. I got a sign that you find offensive. That's not a law. Where in the Maryland Criminal Code does it say you cannot have an offensive political sign? Because free speech is not open to your interpretation.
The relationship between free speech and obscenity has a long history within the courts that stretches back to the Revolutionary era. Just 7 years after the Founding Fathers amended the Constitution to state, quote, "Congress shall make no law abridging the freedom of speech," the Federalist-controlled Congress enacted the Sedition Act of 1798 to prohibit defamatory speech against the government. Ironically enough, the act targeted political speech, which is now considered to be one of the most constitutionally protected forms of speech. Over the years, the Supreme Court developed various doctrines and precedents to regulate which types of speech were entitled to First Amendment protections and the manner in which they may be expressed. In all that time, the Supreme Court has yet to develop a comprehensive legal definition of obscenity, but the roots of its current understanding stretch back to the 1934 case of United States versus one book entitled Ulysses. In the case, the court held that a work investigated for obscenity must be considered in its entirety and not merely judged on its parts. 23 years later, the court ruled that obscene material was not protected by the First Amendment, and could be regulated by the states rather than by a universal federal standard, in the case of Roth versus United States. The Roth case also established a 5-part judicial standard to determine whether speech was obscene, which relied primarily on an average person's application of contemporary community standards. In the 1973 case of Miller versus California, the Supreme Court quantified the obscenity standard previously established in the Roth case, and created a new 3-prong test for obscenity, which became known as the Miller test. The Miller test for obscenity includes the following criteria. 1. Whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to prurient interest. 2. Whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. And 3. Whether the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. The Miller test remains the legal standard of today, despite the fact that obscenity is still one of the most controversial and unsettled areas of First Amendment law, and justices have been relatively vocal about their struggle to define it. In the 1964 case of Jacob Ellis versus Ohio, Justice Potter Stewart noted that he could provide no clear definition for obscenity, but did declare, quote, "I know it when I see it." The use of vulgarities has endured a similar degree of scrutiny within the courtroom, but with much more palpable results. In the 1971 Supreme Court case of Cohen versus California, the court held that profanity is protected under the First Amendment, with Justice John Marshall Harlan noting, quote, "One man's vulgarity is another's lyric." Given that Mr. Porter's sign contains a political message specifically designed to express dissent for government action, it is highly unlikely that the sign would be found to be obscene by a court, and the Supreme Court has plainly upheld the right to use profanity in protest. Mr. Porter is well within his rights to protest with his sign, regardless of whether it offends other people.
I understand. We just got a call for it.
I understand you got a call. You made your best shot. I'm not leaving because I haven't broken any laws.
Hey.
Okay, there's a thing called disorderly conduct.
I can't hear you.
There's a thing called disorderly conduct. If somebody finds your sign and your actions to be disorderly in public, okay, then that is a charge, and we can ask you to leave. And failure to do that, you can get arrested.
Get your commanding officer out here because this is political free speech, and I'm protected under the First Amendment.
Here, Officer Arnold informs Mr. Porter that if someone were to find his actions to be disorderly, then he could be arrested for disorderly conduct. Like many states, Maryland has legislated extremely vague and constitutionally questionable laws regarding disorderly conduct. Maryland Criminal Code 10-201 states that a person may not willfully act in a disorderly manner that disturbs the public peace. And while the code offers a thorough definition of which locations are considered public, it fails to elaborate on what acts would be considered a legitimate disturbance. Many states and municipalities have attempted to use the broad language of similar statutes to bottleneck First Amendment rights, and one of the most notable cases, which draws many parallels to this interaction, is the 2011 Supreme Court case of Snyder versus Phelps. In the case, members of the extremist Christian cult known as the Westboro Baptist Church were protesting U.S. Marine Lance Corporal Matthew Snyder's funeral in Westminster, Maryland, after he passed away while serving in Iraq. The Westboro members stood on a public sidewalk near the funeral and displayed signs with vulgar and disrespectful messages about American soldiers, and went on to publish statements on the church's website that denounced Lance Corporal Snyder in particular. The soldiers' family sued several key members of the church, and the case eventually made its way to the Supreme Court. In an 8-1 decision, the court ruled in favor of the Westboro members, and agreed with the Fourth Circuit Court that the protest signs and language on the church's website were rhetorical hyperbole and figurative expression, rather than assertions of fact, and were therefore entitled to First Amendment protection. In the majority opinion, Chief Justice John Roberts stated, quote, "What Westboro said, in the whole context of how and where it chose to say it, is entitled to special protection under the First Amendment, and that protection cannot be overcome by a jury finding that the picketing was outrageous." Alone in his dissent, Justice Samuel Alito began his opinion by stating, quote, "Our profound national commitment to free and open debate is not a license for the vicious verbal assault that occurred in this case." And he went on to add that while free speech is essential, it should not be used to torment innocent victims. Nonetheless, the court essentially concluded that regardless of the outrageous and offensive nature of the church's speech, it was protected all the same. Although Mr. Porter's sign is highly offensive, it is very unlikely that a court would find his protest to be in violation of Code 10-201. And Officer Arnold's suggestion that Mr. Porter's conduct could be perceived as disorderly was baseless and served no lawful or investigative purpose.
Why are you shaking so much? Are you on the influence of anything?
Oh, now you're going that route, trying to say I'm on drugs.
I'm asking you. You're shaking like a leaf.
Sir, we're not trying to be nasty to you or anything like that.
It's free speech and you can't do anything about it. Call your state's attorney's office. I talk to my lawyers every day. I'm in the newspapers. Every state's attorney's office reviewed it and said you can't do anything about it. It's free speech. You're not even supposed to be talking to me.
Sir, I'm not arguing on that.
Okay.
You're right. You're right about free speech. We have a call because people are offended by your sign. So.
But I didn't offend them. They offended themselves by not liking the choice of words I have for the governor.
Okay. You live around here, sir?
I'm not making any statements.
Okay.
Other than the fact I haven't committed any crimes and you know it.
Hey, sir. I never said you committed a crime.
You said I was disorderly in public, and I'm not.
No, actually, I didn't say that.
I'm engaged in constitutionally protected activity, and you cannot make any law that will infringe upon it, nor apply any law that infringes upon it.
Sir, all I did was tell you why I'm here.
Okay.
I called about your sign.
This guy said I'm disorderly.
I said if somebody
Question
finds
for
your
you.
actions to be disorderly, then they would be disorderly, right?
No, absolutely not.
That's
My
exactly
my
what
free
I said.
speech is
So
not
you want
contingent
to-
upon someone else's emotions.
Okay.
You know that.
I have a question for you. We haven't been nasty to you at all. We've come here to
I'm
talk
just
to
telling
you.
you
And
what-
you've
He
been-
said he's going to arrest me for disorderly.
He didn't
I didn't say that. I said
He
if
did.
someone finds your actions to be disorderly and disturbing of the peace.
I'm sorry,
then
but they're
you
not
could-
judge, jury, and
then you
executioner.
could be arrested.
Could be.
Could be. That's all I'm saying.
I'm engaged in constitutionally protected
There's not-
activity,
in my
sir.
statement, there was an if.
Oh, you're giving me what ifs and hypotheticals now.
That's right.
All right, let me explain something to you. I'm engaged in constitutionally protected activity,
Okay.
and I'm not out here protesting you guys are. So why are you all so personally pissed off that I don't like Governor Hogan?
Nobody is.
No, I'm not mad. Or
I don't like him.
that.
I mean, is my sign not? Is it too subtle?
You're entitled to your opinion.
I'm entitled to be protected by the First Amendment, wrap it around me like a big old blanket while I stand out here with my giant Larry Hogan sign. I don't like the governor.
I won't comment on that sort of stuff. I'm just doing my job.
You understand we're here for a call for service. We're not here because we want to be, right?
Oh, you're here because you want to be. You should have told him there's no crime. You should have said there's no crime.
We have to come out for everything. If we get a call, we have to come. We have to come out here. That's it.
Mr. Porter makes the point that the department could have informed the 911 callers that his protest was legal rather than responding to the call, and Officer McKenzie tells him that they are obligated to respond to all calls under any circumstances. I have discussed the law enforcement chain of communication in a previous episode, which I will link in the info card above. But Mr. Porter's point highlights specific inefficiencies within the communicative process that appear to have feasible and practical solutions. In our current system, there are no national regulations for hiring or training emergency dispatchers, and states are free to draft their own legislation for ensuring that their dispatchers are competent. Some states have elected to develop comprehensive certification programs and stringent experience and educational requirements for dispatchers, while other states have no requirements at all. Even in states with more rigorous requirements, like Florida, the training does not include basic legal topics or civilian rights. If states were to mandate that emergency dispatcher training programs include information about fundamental civil rights and constitutionally protected expression, perhaps less resources would be wasted on calls such as this interaction. Officer McKenzie puts forth the notion that officers are required to respond to all calls no matter what. However, higher courts have ruled otherwise. In the 2004 D.C. appeals case of Warren versus District of Columbia, the court determined that members of law enforcement cannot be held liable for failing to adequately protect citizens, and based its decision on, quote, the fundamental principle that a government and its agents are under no general duty to provide public services, such as police protection, to any particular individual citizen. The logic of the court was that if every crime victim were able to recover damages from their local police department every time a crime was committed, it would result in an unproductive policing system. No law enforcement agency is capable of protecting all citizens from all criminals at all times. But the Warren ruling effectively established a precedent that shields officers who neglectfully allow crimes to take place, as was the case for Broward County Sheriff's Deputy Scott Peterson, who claimed that he had no legal duty to protect the students inside the high school he was assigned to protect during the tragic incident in Parkland, Florida, just under 3 years ago. It is possible that some departments have drafted policies that require them to respond to every call, and after searching through the Bowie Police Department's publicly available policies, I was unable to locate any, but it is possible that the policy exists in the official manual. Although not required by law, it is entirely possible that Officer McKenzie is correct that Bowie officers are required to respond to every call due to policy, but this interaction demonstrates how such a policy could be unproductive.
What was your name?
Officer McKenzie.
Mackenzie?
Yes, sir.
Arnold? B. Arnold. Am I being detained? No, I'm free to go. I'm free to continue protesting also.
You're free to stay here too.
Absolutely, it's a free country. I'm glad you know that. Make sure you recognize that when you try to charge me with disorderly conduct because you don't like the content of my free speech.
Why are you being nasty?
Because I don't like it when cops try and tell me what is and is not allowed on a political
He
sign.
didn't do that. He told
This
you.
guy did. He said that my free speech could be considered disorderly because someone got offended and has thin skin. I'm sorry, but every person on Facebook named Karen doesn't determine my free speech rights. I mean, seriously. I mean,
You're a
I don't.
nasty dude. You know that?
I am a nasty
You
dude.
know, if you want to get your point across, if you're just a little nicer to people.
Why would I care? This is my message verbatim. This is right from my heart.
Well, there's
This
no
is
reason-
my deep felt political belief. It's my protected free speech,
That's
and I'm going to
fine, but you're
continue
going
to
all about
display it.
the wrong way.
What's the right way?
Be kind to us. We haven't been nasty to you at
This
all.
guy said he's going to arrest me for
I just said I was
disorderly.
gonna arrest you. Rewind the tape. I said you could be if someone found your conduct to be disorderly and disturbing their peace. Okay, that is the law.
So as long as you're not jumping in traffic or causing any harm to people.
Or running with scissors,
all
or
that stuff.
taking candy from strangers,
Whatever
getting in the
you-
back of a van. I know.
Whatever you say.
Yeah.
Whatever you say. You want to stand here and hold the sign?
That's what I'm going to do.
Okay. All right. So we're clear.
Have a nice day.
Hey, you too, buddy.
I will.
Nice meeting you, sir.
Same to you.
Have a good day.
You too.
After mingling about for several minutes, the Bowie officers eventually left the scene without further incident, and Mr. Porter continued to protest for another 3 hours with no issues. Mr. Porter told me that he filed an unofficial complaint against the officers by sending the video to Bowie Mayor Timothy Adams, Police Chief John Neske, and the city attorney, who assured Mr. Porter that he would look into it. Mr. Porter went on to say that he has no intentions of filing a lawsuit and that he has not heard from the department since the incident. Overall, Officer Arnold and Officer McKenzie get a C, because although they remained within the bounds bounds of their authority, the officers attempted to discourage Mr. Porter from exercising his rights, displayed a fundamental misunderstanding of the First Amendment, and wasted city-funded time and resources on the scene of a call with no crime. Officer Arnold's insistence that Mr. Porter could have been perceived as disorderly only served to escalate the encounter and could easily be perceived as a veiled threat. Although Officer McKenzie changed her position during the interaction, when she initially arrived on the scene, she told Mr. Porter that she couldn't let him hold up that sign. Both of the officers arrived on the scene with the intentions of infringing upon Mr. Porter's constitutional rights, and it appears as though both officers believed they were within their authority to do so. Ultimately, the officers did respect Mr. Porter's rights, but this interaction leaves little doubt that the Bowie Police Department could use more training on the First Amendment and its protections. Mr. Porter gets an A+ for peacefully exercising his First Amendment rights, remaining cool and collected throughout the encounter, and for standing firm in the face of Officer Arnold's threats. Mr. Porter deserves recognition for having the passion necessary to carry out a lone protest, and the diligence to ensure that he did so legally. Mr. Porter was sure to tell me that he does not necessarily consider himself a First Amendment auditor, and that his mission was focused on Governor Hogan, but he did retain an attorney in the event that his protest was thwarted by police. Mr. Porter has had several interesting encounters with police, and I highly recommend checking out his channel. You can find a link in the description below. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to like and subscribe for more police interaction content.